When you hear about one nation's military involvement in another country, how do you react? Do you feel anger toward that nation, or do you see it as inevitable? Do you expect the United Nations to act as a mediator on the global stage? In reality, the situation is far more complex than it may seem. In the following video, we will explore how different theoretical perspectives can be applied to international affairs. Stay tuned.
The landscape of global security is defined by a constant tension between the borders on a map and the use of force. We saw the world shaken when Russia launched a full-scale invasion of Ukraine in 2022. Then imagine the shockwaves of January 3rd, 2026, when the United States conducted a military operation on Venezuelan soil to arrest Nicolas Maduro. These events force us to confront the fragile nature of sovereignty. They beg the question, do the rules of international law actually bind the powerful? And who, ultimately, is responsible for keeping the peace? Let's look at the first question. Can a country conduct a military operation within another country without that country's prior consent? The starting point of international law is the United Nations Charter. Specifically, Article 2, Section 4 prohibits the use of force against the territorial integrity of any state. Generally, military intervention is illegal unless it falls into two specific exceptions: self-defense under Article 51, or an authorization by the UN Security Council. However, the reality is complex. Russia's invasion of Ukraine in 2022 was widely condemned as an act of aggression because it did not fit these exceptions. But what about operations like the capture of a foreign leader or strikes against non-state actors? In modern practice, states often bypass the requirement for consent by invoking the unwilling or unable doctrine. This legal theory suggests that if a host state is unwilling or unable to suppress a threat, such as terrorists or criminal regimes, emanating from its territory, a threatened state may intervene in self-defense. The United States, for instance, has historically relied on this standard to justify operations in countries like Syria without the government's permission. While controversial, this doctrine attempts to bridge the gap between respecting borders and stopping threats that ignore them. This brings us to our second question. Are all countries obligated to comply with international law? Technically, yes. The UN Charter is legally binding on all member states. Furthermore, there are norms known as jus cogens, fundamental principles like the prohibition of aggression and genocide, from which no derogation is permitted. However, enforcement is difficult. When states fail to comply, international law adapts to fill the vacuum. We see this in two major legal evolutions. First, the shift from state sovereignty to individual responsibility. Historically, international law focused on states, but the rise of international criminal law and institutions like the International Criminal Court, ICC, means that individuals, even heads of state, can be held criminally responsible for atrocities regardless of their official position. This provides a legal framework for actions like the arrest of a dictator, treating them not just as a political enemy, but as a criminal subject to extraterritorial jurisdiction. Second, we have the doctrine of the responsibility to protect, or R2P. Adopted at the 2005 World Summit, this norm establishes that sovereignty is not just a right to control a territory, but a responsibility to protect the population within it. If a state manifestly fails to protect its people from crimes like ethnic cleansing or crimes against humanity, that responsibility shifts to the international community. This creates a normative basis for intervention when a state turns against its own people. Finally, what is the role of the United Nations in all of this? Should the UN take responsibility for managing the international order? The UN Security Council was designed to be the preeminent organ for maintaining international peace and security. It has the unique legal authority to authorize coercive measures, including sanctions and military force, to address threats to peace. However, the UN's ability to manage order is severely constrained by the veto power of the 5 permanent members: the US, UK, France, Russia, and China. During the Cold War and again in recent years regarding Syria and Ukraine, this veto power has often paralyzed the Council. When the Security Council is deadlocked, it cannot effectively authorize intervention, leading states to act unilaterally or through regional coalitions. Despite these failures, the UN remains essential for legitimacy. Even when powerful states act alone, they often seek to frame their actions within the UN principles to avoid being seen as rogue actors. While the UN struggles to physically enforce order due to political rivalries, it remains the central forum for defining what is considered lawful behavior. We are left with a system that is both rigid in its rules and fluid in its application. As we analyze interventions from Eastern Europe to South America, we must avoid simplistic conclusions. No one can definitively say which idea is better or worse, as international relations are too complex to be confined to a single definitional framework. It is important to broaden our understanding of global events through sound theories and critical thinking, rather than through fluctuating emotions or irrational perspectives. Thanks for watching.